Item for delivery of order. Item number 1, bill application 1475 of 2024.
Petition dismiss.
For motion bail application, item number 2.
Wait for you. This is 439 application, my lord. The petitioner arrested on 6/6/2024. The FIR is at page 11, my lord. The present petitioner is falsely implicated in this case. And the co-accused named in the FIR has already been released on bail. His order is at page 18, my lord.
Mr. Das.
There was some allegation against them. that
Same
they
allegation,
attacked
my
the
lord, is
police.
there.
Police also made out.
Same allegation against both the accused. Well, I think my lord, the further custodial interrogation is.
So you were behind the bar for last 24, sorry.
I'm for the
20.
6/6/2020. Near about 24
20?
24 days, no? 24 days.
About 24 days.
Okay. Third, Mr. Your good name.
R. Islam.
Learned counsel for the accused and Mr. Das, learned additional PP for the state response. D. Das. This pair number 2, then pair number 3. The learned counsel for the accused, Mr. R. Islam, submits that the accused was arrested on 6/6/2024 and since then he has been languishing in jail for last 24 days. Further, Mr. Islam submits that the accused is innocent and not involved with the offense alleged in the FIR and that one of the co-accused, namely Safiul Islam, alias Pastor, has already been granted bail by order dated 17/5/2024 in BA number 1360/2024 and the present accused is also stands in the same footing and therefore it is contented to allow the petition. Whereas Mr. Das, learned additional PP, has opposed the petition on the ground that there are sufficient on the ground that there is allegation against the present accused. Therefore, is having heard. It appears that the accused was arrested on 6/6/2024 and since then he has been languishing in jail for last 24 days. Further, it appears that by order dated 17/5/2024, one of the co-accused has already been granted bail in BA number 1360 of 2024. Having considered the period of detention and also considering the nature and gravity of the offense, and also considering the fact that one of the co-accused has already been granted bail by this court by order dated so-and-so in the BA number so-and-so, this court is inclined to allow this petition. This provided that on furnishing a bond of rupees 50,000 with 1/0 like amount to the satisfaction of the learned CJM
CGM मतलब South Salma बनकर
South Salton.
मार सकते हैं.
Item number 3.
This is a bail application 439 prepared by Undertale Prison, Imperial Order page 22, madam. Now, evidence, page 22.
Let the scan copy of the record.
Scan copy.
When Mr. Das, of course, Wesley will come for it.
By registry, my lord. Yes.
On 19 July,
So that immediately after reopening.
on 16 July.
16, ma'am.
Item number 9,
Code 39 application of, code 39 application. Arrested on 27/4/2014, 2024. In connection with King Kong case number 27 of 2024 under section 306. And also 2 days behind the bar.
What is the mandatory period of detention?
60
My
days.
lord, that is why, my lord, I have instructed my office to, my lord, have information as to whether, my lord, charge sheet has been submitted or not, my lord. My lord, let it be taken up after some time, my lord. In the meantime, I may get information. My lord.
item number 10,
Right, it's a 439 application, my lord. Page 23 is the FIR, my lord. Here, you should find, my lord, allegation is primarily against one Ajoy Baspor and Monos Baspor, my lord. And they took on false promises, my lord. They took several documents from the informant, my lord. And, my lord, thereafter, they procured loan, my lord. Now, what happened in this case, my lord, on similar allegation, my lord, all documents we have annexed, my lord. The present accused was arrested in connection with the first case, my lord, wherein Monos and Ajoy was also named, my lord. And though that is, my lord, what should find in the next page, my lord, that is page 30, my lord. This refers to, my lord, Lokakem police station, my lord. Page 30, my lord. So here, same modus operandi, my lord, that Monos and Ajoy, my lord. More or less same allegations. Now, in that case, my lord, the present accused was arrested, my lord.
In that FIR, allegation was against one Sandan Baswar. Sando Baswar.
Yes, but different informant, but the accused persons are same, my lord. What I meant, my lord. Page 30, those two names, my
No,
lord. Ajoy and
in page 23, whether that person was accused there.
Yes, my lord. So, no, informant was not there, different informant, my lord. But allegations are same, that. Why? Because
Let us say come das.
why only one thing, he has shown arrested, my lord, and he had undergone, my lord, that stent, my lord, implant, my lord, RCA, my lord, that,
Maybe, but the quantity of amount
my lord.
is
Yes,
very
yes,
high.
yes. My lord, can I pray one thing, my lord, other case, he has been granted bail, so can it be on any second or third, my lord, from Horum, my lord?
Second or
My lord, during the vacation, second or third, my lord?
whether vacation code is there.
Yes, my lord.
Vacation code is there. Kun thana? Kun thana? No.
I'll find it.
Okay.
Third, my
Third.
third. Much obliged.
item number 11,
May please your lordship, 439 application. Accused was, petitioner was arrested on 10/2/2023. Charge have been framed on 12th of January 24. Lordship, LCR may be.
Sir is already framed.
Yes, lordship.
Whether any witness examined?
No, lordship.
No. Are you sure no witness has been examined till date?
I'm not sure, but
You were
as
not
per
sure.
my information, no witness has been examined.
Okay, LCR on COVID
on 17 July,
70.
Lordship, maybe 18th or 19th.
Okay,
on 18 July.
18.
Obliged.
Item number 12 by VC,
May I lordship, please?
Yes.
Yes. This is an application for 439, my lord. Now, he was arrested on 24th of June.
20?
Yeah, when not a longer period he in custody, but one very important point I would like to highlight it before this honorable court, my lord. The allegation is that some false allotment certificates were issued from the West Revenue Circle of Dibrugarh. That was all certificates dated 29th of August 2022. He was transferred, he is a Latmandal. He was transferred from the West Revenue Circle and joined at Tingkhang Revenue Circle on 25th of February 2021. So at the time,
Mr. Doctor, your voice is not clear.
Lordship, may I clear now?
Yes, now clear.
So, firstly, I would like to contend it that this Latmandal, this petitioner, he was in West Revenue Circle up to 24th of February 2021. All the alleged land allotment certificate were issued on 29th of August 22. And in the FIR, I was not named in the FIR, my lord. In the FIR, the circle officer alleged against the beneficiaries of all those land allotment certificate. Lordship, you may kindly have a look at the FIR at page 16.
Yes.
The last line, Lordship will find that the allegation against the landholder certificate holder. That is, those are the beneficiaries. Now, in the forwarding report, Lordship will kindly have a look at page 22, second paragraph.
Yes.
Second paragraph, that on the basis of an allegation made by some other co-accused, I was arrested. During the course of investigation, the arrested accused person, Sri Joy Kumar Hajarika, president of Village Land Management and such, has been brought in police remand for 4 days, and he was thoroughly interrogated. During interrogation, he stated that one another alleged accused person, namely Mukhtiar Hussain, the petitioner herein, my lord, who was the Latmandal during the time of offense. That is not the correct. I was not there. Is also involved with him. The accused person, Sri Joy Kumar Hajarika, also stated that Muhammad Mukhtiar Hussain has made him like an agent who works as collection of document and money, and the same handed over to Mukhtiar Hussain. After that, all the land allotment certificate, along with revenue paid certificate, to Sri Joy Kumar Hajarika, and the same has been distributed by Joy Kumar Hajarika. That was the allegation. Now, the important part of the matter to be looked into by this honorable court, my lord will find that they have not communicated the ground of arrest. Lordship will kindly have a look, the arrest memo, page 20. It's a computerized form wherein there is no column of ground of arrest. And as per the recent judgment of the Supreme Court on 15 May of 2024, unless there is the communicate forthwith the ground of arrest, the entire custody and the remand order is illegal. So it is a violation of section 50 and also article 22(1) and also 22(5). And recently the Supreme Court in a Probir Pukasto case, it was laid down that unless this ground of arrest communicated, the arrest and remand is held to be illegal. May I place the judgment, my lord? Or in alternative, today is the last court of the before vacation.
No, Mr. Doctor, let the city come.
Lordship, would you paragraph 30, Lordship, kindly have a look. Paragraph 30, my lord. Hence, we have no agitation in reiterating that the requirement to communicate the ground of arrest or the ground of detention in writing to a person arrested in connection with an offense or a person placed under prevention of detention as provided such and such of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or the detention being returned illegal as the case may be. In that case, it is the UPA, the person was arrested under the UPA. And in 49, paragraph 49, the Honorable Supreme Court says ultimately in conclusion, it may be reiterated at the cost of repetition that there is a significant difference in phrase reason for arrest and ground of arrest. The reason for arrest, as indicated in the arrest memo, are purely formal character parameters, that is to prevent the accused person from commuting any further offense for a proper offense such and such, such and such. This reason should commonly apply to the person arrested on charge of crime, whereas the ground of arrest would be required to be contain all such details in hand of the investigation officer for necessitating the arrest of the accused. Simultaneously, the ground of arrest in form in writing must convey to the accused all basic facts when he was being arrested, so is provided to him. That was not done. And ultimately, the Supreme Court held in that case that the detention and the remand order is illegal and pass an order for release forthwith. So this basic requirement of the law not provided apparently in this case.
Yes.
Even if my lord, my last submission, even if lordship has been inclined to peruse the CD, it may be fixed on the vacation on the 2nd or 3rd, my lord. 2nd or 3rd.
Apart, Mr. P. Dr. Lord New Council assisted by Nixon.
Yes, taken.
Learned Council for the accused and Mr. D. Das, learned additional CP for the estate respondent. This application under section 439 services prepared by accused Mukhtiar Hussain, who has been languishing in jail as in connection with Border of PS case number 59 of 2024 under section 120B, 420, 468, 471, 34 IPC since when he was arrested?
24th of June.
Since 23rd, 6, 2024. This to be noted here that about the case has been registered on the basis of one FIR lost by Circle Officer Dibrugarh West Revenue Circle, Dibrugarh on 13th of June 2024. Mr. Dr. Learned Senior Counsel for the accused submits that while causing arrest of the accused, the investigating officer has not communicated the ground of arrest to the accused, no, to the accused and his family members. And in view of the judgment of Honorable Supreme Court in the case of Probate Protesto versus State within bracket NCT of Delhi, reported in 2024, SCC Online SC 934. For non-compliance of for failing to inform the ground of arrest to the accused and his family members, the accused is entitled to bail. Whereas Mr. D. Das learned additional PP submits that at this stage, the case hearing may be called for to ascertain as to whether the ground of arrest was communicated to the accused and his family members or not. But having heard the submission of learned advocates at outside, the result of the case hearing is found to be necessary, and accordingly it is provided that Mr. Das, the learned additional PP shall produce the case hearing before this court on 3rd of July.
Grateful, Lordship.
Number 13.
May I please, Lordship, such-cited case matter relates to NDPS Act. Charge is not yet claimed.
When he was arrested?
He was arrested in
10-9.
10/9/23.
Heard Mr. B. Football, learned additional, learned counsel for the accused, and Mr. D. Das, learned additional PP for the establishment. This application under section 439 services prepared by accused John Patel, who has been languishing in jail in connection with Osisto PS case number 539 of 2023 under section 21C/29 of the NDPS Act. Mr. Foucault, learned counsel for the accused submits that After completion of investigation, the IO has already laid charge sheet before the learned trial court. In view of the submission of learned counsel for the accused, it is provided that the perusal of the case record is found to be necessary, and accordingly it is provided that registry shall call for the scanned copy of the record as well as the case from the learned trial court. This is the matter of
On 18 July. Item number 14.
May I please, Lordship, 439 application, Lordship. Commercial quantity is there, Lordship. CD may be called.
charge sheet not submitted.
Not sir.
CD on Mr. Das,
CDM
when?
on reopening
15 July.
15.
15 July.
Highly obliged, ma'am.
Item number 15.
May I please, your lordship, CD may be called for.
Same commercial quantity.
Charge sheeted or not charge sheet? Charge sheeted matter or not charge sheet?
Commercial.
Charge sheet submitted or not
No.
submitted?
Charge sheet is not, they have not annexed any charge sheet. Perhaps not submitted.
CD on when?
Yes, the restaurant 17/6. 17th this month.
Das.
10 days.
Okay.
17 July.
Item number 16.
My lord, this bail application was earlier rejected by the Honorable Justice Nandi Lordship.
Honorable Minister,
Honorable Justice Nandi Lordship.
always before appropriateness.
Item number 17.
None appears to the accused and call, this is the matter after review.
Item 18.
May it please, your lordship, 439 of service and FIR is page number 8.
Where is the vernacular?
Vernacular is, your lordship, page number 13.
Let the CD come. CD on.
After vacation, 25th July,
Item 19 July.
19th. March.
Item number 4.
Please, your lordship. Lordship, 438 bail application, my lord. FIR is page 12, my lord, the type copy. And photocopy is page, my lord, the 15, my lord. May I read, my lord?
Yes.
My lord, FIR is dated, my lord, to 21/3/2024. but in the content, my lord, maybe
This
some
is second
mistake.
application or first application?
My lord, the first application, my lord.
What is this annexes 2, page number 70?
Sorry, my lord.
Annexer 2,
My lord.
page number 17.
My lord, in the my lord, order of the my lord, co-accused, my lord, release on bail, my lord. Now, one accused release on my lord 17/5/2024, and another my lord today is item number 2, my lord. As I understood, your lordship granted bail, item number 2, my lord. Accused number, my lord, and the petitioner is the my lord, third accused, my lord. My lord, kindly see, my lord, the affair, my lord. The involvement of the petitioner is nothing, my lord. May I read, my lord, page 12, my lord, second particular portion, my lord. We witnessed suspicious motorbike movement in that area. Tactically getting closer to apprehended a person who himself identified as ASG Azad Sheikh, son of so-and-so. Few meters away, we witnessed Shainur Islam, the son of so-and-so, village Sorkasharipra, and person known as Bashar, might be Elias, along with 8 to 10 cattle, which are guided toward international border. Face them. They crossed the stream of Jinjiram River toward Meghalaya. From there, they threatened the police party of dire consequences. They also pelted stone to the police party, which damaged the police vehicle and also injured my right knee. Taking advantage of chaos, Azad Sheikh fled away toward Meghalaya. However, we found his motorbike, Pulsar, bearing number so-and-so, my lord.
If there
This
is
is
nothing
similar to
in the-
item number 2, my lord,
But-
same PS case number.
Same PS case.
Same PS, item number 2, my lord. That has been disposed of. That is, of course, BA, my lord, bail application. And this is anticipatory bail. Same FIR.
If there is no allegation against you in the FIR, why you are appealing against?
My lord, other two accused, my lord, they are involved in the, my lord, threatening and pelting stone to the, my lord, police party, my lord. Regarding my part, my lord, is the first two line, my lord. There is a suspicious movement of motorbikes, my lord. My lord, what happened, my lord, on the night of incident, my lord, the petitioner, my lord, moved toward Halidigunj to procure medicine for his mother with motorbike, my lord. Suddenly, his motorbikes on the way, my lord.
No, whether you have received any notice from the
No,
IO,
No, my lord. No.
then
No, my lord, no.
whether you have been asked to appear before the IO.
No, my lord, but since his name is appearing, he filed a bail application before the, my lord, before the, my lord, session court, my lord. But learned session court rejected his bail prayer, my lord. I have annexed this order, my lord. So, this is, my lord, well, page 20.
Your name is there in the FIR.
FIR is, yes, lordship, my name is available in the, but my lord, kindly see the involvement of my, in the
No,
incident, my
if there
lord.
is no involvement, why does a learned session just
Well, is it-
dismiss you here?
Totally, my lord, substantial. At that time, my lord, is a preliminary stage, so my lord, bail was rejected. my lord.
Preliminary stage? No, learned court below has a peruse the case diary. Thus, produce the case diary
My,
on vacation court,
My lord, no, my lord, after, my lord, some
After-
protection may be given because he was a, my lord,
no protection. Your name is there.
on,
on 15 July. my lord. Highly obliged, your lordship. For bail hearing, I think about 5.
bail hearing, yes. No, bail hearing.
May I see the lordship, my lord? Your lordship, kind enough to up to date case. Even I have filed an additional affidavit, my lord.
Regarding?
My lord, I bring some RTI report, my lord, in the record, my lord. Flag marks X.
RTI report regarding,
Regarding the correctness, genuineness of my documents, my lord. Since my lord, last 2 months, my chamber has been closed down physically, mentally, financially, I have suffered.
So I asked my own brother-in-law to file RTI. For a moment, just the allegation in the affair which was brought against that certificate, page 12, page 33, annex at 12. In the affair, it is alleged that my BDS certificate registration is suspected to be verified from the Maharashtra Dental Council. May I read, madam? Such and such. We acknowledge the receipt of your RTA application dated such and such seeking certificate clarification on the authenticity of registration certificate under number such and such under the provision of RTA Act 2005. After thorough verification of our records, we confirm that registration certificate bearing registration number such and such issued to the Saiful Islam Chaudhary, this is petitioner, is genuine. Furthermore, we have ensured that issuance of this certificate is in compliance with the Dentist Act 1948, affirming its validity under the relevant legislative framework. Should you have any further inquiries or require additional assistance, please don't hesitate to contact us. So this is from the allegation in the affair, if your lordship kindly for a moment. Page 13, my lord.
No, not necessary. You are on interim bail.
My lord, I have it.
Yes, Mr. Das.
Well, he is on interim, and after granting interim, he appeared before the IO, and he has submitted certain certificates, which he has also annexed to the petition, and additional affidavit. Those certificates are to be verified, are yet to be verified from the original source of place. That is where he
Maharashtra Dental.
Maharashtra and Mira. So that part is there, but his statements are recorded. So otherwise, he has cooperated with the investigation. Now these things are from since they have to obtain records from verify from different states, it will take some time.
Well, for a moment, page 36, annex 13, from the myriad also under RTA. Next page, followed by from the university concerned by what my learned friend say, it is also I have obtained by. When I am reading the
He has obtained all these things through RTI. There is one thing. The IO cannot rely on these things, this type of reports. He has to satisfy himself from the original source. So
Okay.
My lord.
Lord Mr. A.K. Hussain, learned counsel for the applicant, and Mr. P. Das, learned
And it
additional
is also
counsel
genuine.
for the state respondent. Pardon?
sorry, my lord, page 36 also confirmed that my certificate from the university is also correct.
Here number 2 and 3, order dated 29/4/2024. Mr. Hussain, learned counsel for the applicant, submits that this court by order dated 29/4/2024 was placed to grant the privilege of interim period bail, and thereafter he had appeared before the IO and cooperating with the investigating agency. Further, submitting one additional affidavit. Now, further referring to the additional affidavit submitted by the accused applicant, Mr. Hussain submits that the applicant had filed an RTA application to Maharashtra State Dental Council in respect of the genuineness of the certificate issued to him, and the Maharashtra State Dental Council by Annex 12 of the petition has confirmed that the certificate was issued in compliance with the Dentist Act 1948. And the certificate is genuine. Mr. Hussain, under the aforesaid facts and circumstances contended that the interim order dated 29/4/2024 may be made absolute in the same terms and condition. On the other hand, Mr. T. Das, learned additional PP has participated before this court and confirmed that the applicant had appeared before the IO and cooperating with the investigating agency. However, Mr. Das submits that the IO has to confirm the genuineness of the certificate of the applicant, and it will take time. And what is the stage of investigation?
investigation is on. The item number 6 is also same. same affair same. So about him, nothing, I have not found anything in the case, there is no progress, So investigation is on.
And that the investigation is still going on. Having heard the claim. It appears from the case diary that the IO has achieved some progress in the investigation of the case. And further, it appears that pursuant to order of this court dated 29/4/2024, the applicant had appeared before the IO and cooperating with the investigating agency. Further, from the annexure 12 at page number 33 of the petition, it appears that the certificate of the applicant is genuine and issued in compliance with the Dentist Act 1948. And the same has been confirmed by the Maharashtra State Dental Council. In the reply dated, RTA reply dated 14/6/2024. Having considered about and also considering the submission of learned advocates of both the parties, this court is of the view that custodial interrogation of the applicant may not be required in the interest of investigation, and therefore the interim order dated 29/4/2024 is hereby made absolute in the same terms and conditions.
Highly request.
Item 6.
Item 6 was the same case there, I could find nothing in this with reference to him, perhaps he is not in interim, not on interim.
My lord.
No interim was there, and therefore, I could not seize anything or neither he could be interrogated.
And I am interested to appear before the IO and submit my
Heard
credentials.
Mr. M.A.I. Hussain, heard at counsel for the applicant, and also heard Mr. Didas, learned additional people for the state respondent. Therefore, I do regarding Mr. Hussain, learned counsel for the accused, submits that the accused is innocent and the applicant is innocent and no way involved with the offense alleged in the FIR, and that he is ready to cooperate with the investigating agency, and therefore Mr. Hussain contended that the privilege of periodic bail may be extended to him. Whereas Mr. Didas, learned additional PP, has produced the case before this court and fairly submits that the materials collected so far in the case diary is inadequate to show any legally prosecutable culpability of the applicant. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents flashed on record, and also perused the case diary with the assistance of Mr. Das, learned additional PP. In view of the materials collected so far in the case area and also in view of the submission of learned advocates of both the parties, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with case number so under section 4, he shall be released on arrest bail on as executing a bond of rupees 50,000 with 1 0 like amount to the satisfaction of the arresting authority. The privilege is however subject to the following two conditions. Last condition, he shall not leave the jurisdiction of CJM Hosai.
Item number 19.
May I please tell us? My lord, the statement of the PWs were called for, it is received, my lord.
Lordship, yesterday was fixed for a recording statement under section 1(3) that was recorded. Next date is fixed for argument on 11/7.
So. My submission, my lord, Caesar witness were not examined as a PWs.
No, which witness has been examined by the learned trial court. This court dealing with bail application cannot examine that matter.
So my lord.
This is not a criminal petition or a writ petition.
PW 7 and PW 8, my lord, may I need the cross examination.
There?
Because in this case, my lord, the Moeda were seized, my lord. But the seizure officer, my lord, has not entered the Moeda's documents or Moeda's mentioned about this Caesar in the Caesar list.
No, no, in
So-
bail application, we cannot examine that matter, sorry.
Well, 2 years, 2 months, my lord.
Maybe, trial is about to complete.
And this is the order of Supreme Court from here, the Guwahati High Court. That's Supreme Court says that at the flank of the trial. Although this is in only order. (11.7) is fixed for argument, lordship. Order will be passed. 11.7.
You go and argue the matter. If the court below has not examined any Caesar witness, then you can file a petition. Under section 311,
Yes.
you avail that remedy. Yeah, we will pass necessary order.
Much appreciated.
Okay.
Item number 7 for orders.
Maybe the lordship, which I filed affidavit lordship, because the details calculation lordship, there is in record lordship.
And you have filed affidavit?
No, my lord, yes, my lord, I have filed earlier affidavit, my lord. But after filing of.
No, what was the instruction on the other day?
Mistake was to give the calculation lordship, whatever, give the calculation area of the area amount lordship. It is instructed to file to both of them lordship, but I have, and his lordship is delaying the matter lordship, so he may not file lordship. He delaying the matter lordship, so he may not file lordship. I have given the total calculation lordship. And that's
My
a
lord,
record lordship.
I have to obtain, my lord, the copy, relevant copy from the learned court below, my lord. Without record, my lord, how I can file, my lord, affidavit?
Like his client.
Why, my lord, my friend is blaming
His
like
client
this way, my
lordship, his
lord?
client is, my client is illiterate lordship, but he given the instruction lordship. And his lordship is a teacher lordship, but he is not, has the instruction lordship. So lordship, I have the given calculation lordship, details lordship.
My lord, mere submission, mere making a statement is not sufficient, my lord. Without record, my lord, only calculation given, my lord, in this affidavit.
Then you show that it is wrong. So lordship.
I have to file objection, my lord, in this regard, my lord.
Devoted the whole lordship. So lordship may kindly give the direction to the DDO lordship, and in between lordship, at least now he will lordship give at least 50 or
No,
20,000
in
lordship.
order to direct the DDO to deduct the amount from the salary,
Yes, lordship.
then we have to ascertain the actual amount.
That amount lordship, what I have given, there is, it is the correct lordship.
Pardon?
It is correct lordship. What I have given lordship.
It cannot be correct, my lord, because in the meantime, my lord, I have paid several, my lord, much amount, my lord, but which is not on record, my lord. On the
Whatever you
basis of
given, I
record,
have mentioned it.
let them produce the record, my lord.
I have
Without
given it.
record, my lord, mere making statement is not sufficient, my lord.
Then why you are avoiding the lordship? He is avoiding the payment lordship till 2012 lordship, but even though I have kept the calculation lordship. And he is not paying lordship. Lordship may kindly give the direction to deduct lordship 50,000 per month lordship in between lordship. He will produce a record lordship, whole record lordship. All lordship trial court record that also may be called for lordship want.
Yes, my lord.
Now, in between
Can-
lordship, the part payment may be make lordship, and if we can say that my calculation is something is more than the internal amount lordship, that may be deducted lordship. That is, I have mentioned lordship.
I have to file objection, my lord, to the against this affidavit, my lord. So, my lord, some time may be granted, my lord.
No, that is, I have the objection lordship. There lordship, I have given calculation lordship. That is, if found wrong lordship. Later it can be adjusted lordship. There is no issue lordship. If
No,
he says
maybe,
that,
but let him ascertain.
if he can sell, he will verify the record lordship. I have verified record lordship. I found this correct lordship. And when in which month lordship, how much he is paid lordship, I have given details. calculation.
Which record you have verified?
Lordship is the trial court, and I have also some order said lordship from after the trial court's final order until lordship 2 months back lordship. I have the record lordship. And prior to that, there is a small amount lordship, and that amount lordship I have mentioned here lordship. There is the issue.
Okay, let him verify it.
Yes,
We'll
madam.
pass the order on next step. Have you furnished one copy of the affidavit to him?
Yes, yes.
Yes, my
I
lord.
mentioned.
Furnished.
Even lordship, my prayer lordship, he will not clear that whole amount lordship in a one installment lordship. He will take part payment lordship. So lordship may kindly give direction in between lordship, he will verify and if he says there is some amount is more, then I will deduct it lordship, no matter lordship.
The amount has to be ascertained first. Okay, heard Mr. M. Hawk.
Yes, sir, lordship.
S. Hawk, learned counsel for the. You go for the applicant.
Applicant.
Applicant and Mr.
A Hussein.
A. Hussein, learned counsel for the respondent, opposite party, stroke respondent. Mr. Hussein, learned counsel for the opposite party, stroke respondent submits that he has received a copy of affidavit filed by the learned counsel for the applicant, and he will submit a reply and price for granting him 1 week
My lord, after vacation.
after vacation. 2 weeks time. Here is accordingly allowed. Recessal is the matter on 15 July. 18,
my lord. 18.
15. 18. Yeah, sorted. 15 sorted.
On the day lordship. 50 plus in this also, vacation doesn't say.
Okay, then 18.
Yes.
18. Because on 15 he will file. It may not be listed along with this petition also on that day.
He may file his reply in between that lordship, so that he may file his reply prior to that lordship. That is,
There is
otherwise he
summer
will file
vacation, my
on the
lord.
day lordship. Yes, filing date is there lordship. Case can file in lordship in between also lordship. Because lordship,
Okay, then 15. 15.
115. Timing item 9.
Charge sheet not submitted, lordship, as charge sheet not submitted, as FSL is not collected, lordship.
FSL is not.
Collected, lordship, so charge sheet not submitted.
So for how many days you are behind the bar?
62 days. 62 days.
62 days.
Case 13 is the
But what is the mandatory period of detention?
60 days.
60 days. So why you have filed this petition before this court instead of filing it before the trial court?
That code is in Dibrugarh.
Yes,
Because it was,
you have to submit a bail bond before.
it was filed, but some objections were there in this application. We are moving the application after the mandatory period.
Heard Mr. R.P. Hazarika, learned counsel for the accused, and also heard Mr. Didas, K.K. Das, learned additional PP for the state respondent. This application under section 439 service is prepared by accused Tano Lokurakan, who has been languishing in Jailasut in connection with Tingkong PS case number 27 of 2024 under section 306 IPC since 27/4/2024. For grant of bail. It is to be noted here that a noted case has been registered on the basis of one FIR lost by one. FIR is at page number 9.
9, page number 9.
Lost by one giving Hendik
Gary Henry.
of Nitai Nogao of Sipsagar on when it was filed
It was
on
filed on
29/8/2024.
17/4/2024.
27.
27/4.
27/4/2024. The sense of allegation made in the FIR dated so and so is that about 10 years back, his daughter Bhanya Prabha Lokurakan got married. And as such, the accused is entitled to default bail, and accordingly, it is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned CJM Dibugar, the accused be enlarged on bail.
Item number 8 for hearing.
So on the other day, I have
Regarding 10.
told you about one judgment of Supreme Court in Wazir Khan versus State of Uttarakhand. Especially page number, no, paragraph number 24. Okay. The last item.
Mary Lordship. Mary's.
Ah.
24. Where an accused is alleged to have committed the murder of his wife and the prosecution succeeds in leading evidence to show light in the present case that shortly before the commission of the crime they were seen together or the offense took place in the dwelling house where the husband also normally resides. It has been consistently held that if the accused does not dispute his presence at home at the relevant time and does not offer any explanation how the wife received injuries or offers an explanation which is found to be false, it is a strong circumstances which indicates that he is responsible for commission of the offense. One more judgment, Lordship, I have one more judgment I have given, Lordship, that is Lordship Khanasaran Singh versus State of Chhattisgarh. Lordship. This is 24 Lordship judgment, Lordship. 2024 judgment, Lordship. Supreme today.
Which paragraph you have relied upon?
Lordship, it is from starting from 10, page number 10 to 10, Lordship, regarding section 106 of evidence Act. Here the Trimukh Maruti and other cases are also discussed, Lordship. Page number 10, 7. Para 10, section 106 of evidence Act. 106 burden of proving facts specially within knowledge. When any fact is specially within the knowledge of any person, the burden of proving that fact is upon him. The 11, the law regarding murder, section 106 of Indian Evidence Act 1872 is well settled. The unnatural death of Kailas Kumar took place in the house of appellant. 12. As per requirement of section 106 of the Evidence Act, the accused was required to give plausible and convincing explanation about the circumstances in which the deceased was found dead in their house. Where an offense like murder is committed inside the house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature and amount of evidence to lead by it to establish the search cannot be of the same degree as is required in other cases. The burden would be of a comparatively lighter character. 13. In view of section 106 of the Indian Evidence Act 1872, there will be a corresponding burden on the inmates of the house to give a cogent explanation as to how crime was committed. that indicates the image of the house cannot give away by simply keeping quiet and offering no explanation on the supposed premises that the burden to establish this each case lies entirely upon the prosecution, and there is no duty at all on the accused to offer any explanation. Therefore, also for para 14 also here Trimukh Marathi case has been discussed on in para 15. It is discussed Lordship Nath Shambhunath and other cases Lordship. Lordship, may kindly skip to para 22. Para 22. It is to be remembered here that homicidal nature of death need not always be proved through direct evidence. It has to be inferred from the circumstances and the nature of injuries noticed on the dead body. The instant case is about the death of wife committed by the husband within four walls of the house. When the assailant is the husband, it is difficult indeed to get direct evidence on the nature of injuries. It is thus concluded that the deceased died homicidal nature of death. Considering the answers given by Dr. Pradeep Kumar Rohan, PW 11 and PW Exhibit P13, 131 to the queries made by the station house officer, police station Khandagaon, and the further considering the nature of injuries which the deceased was found, we are of the considered opinion that death of the deceased was homicidal in nature. It is held accordingly. 23. In the present case, the deceased was found dead in her courtyard, and at that time only the appellant and the deceased were present in the house, and as per the provision of section 106 of the Evidence Act, the burden of proof that the appellant was not present in the house at the time of incident and he was present elsewhere on the appellant, which is admittedly failed to prove in his statement under section 313 of the CRPC. As such, the judgment relied upon by the learned counsel for the appellant, Nagendra Shah, is not helpful of the appellant and the distinguishable to the facts of the appellant present case. Investigating officer Lordship, there was a 25 Lordship. Considering the answers given by Dr. Pradeep Kumar to the queries made by the station officer, the police is of Khandagaon, taking the consideration that the burden of proving a plea specially said by the appellant which may absolve him from criminal liability certainly lies upon him, and he has not offered any plausible explanation. Further, taking into consideration that the appellant was required to explain as to how the deceased suffered such injuries, as the body of the deceased was found lying in the courtyard of the appellant, which he has admittedly not explained in his statement under section 313 of the CRPC, and the material collected by the prosecution, we are of the considered opinion that the above chain of circumstances is complete and lead only to one conclusion, that it was the accused appellant who caused death of the deceased. The view taken by the learned trial court that the appellant is the author of the crime is a pure finding of fact based on evidence available on record. We hereby affirm the finding. In the result, this court comes to the conclusion that prosecution has succeeded in proving its case beyond all reasonable doubts against the appellant. The conviction and sentence as awarded by the court to the appellant is hereby upheld. The present criminal appeal stands dismissed. So also here it has also everything has been discussed, and it is squarely covered our case, Lordship, that whether she is suffering for abdominal pain, that has not been regarding that he has not adduced any evidences, Lordship. And even one more important thing, Lordship, comes from this judgment, Lordship, that Lordship, he could not prove that he was not present at that time in the house, Lordship. He has not taken that plea also, that I was not present in the house. Though in 313 he has simply said I was not present, but he could not adduce any evidence Because here in the judgment lordship para 23, I think lordship. Para 22 lordship, here it is stated lordship that he should have proved that he was not present.
Entire report has to be read as a whole. The report has to be read as a whole, not only the opinion.
In my opinion, this is a summary of the case of the death is due to shock and hemorrhage. Due to hemorrhage inside the abdomen. It is not at the outside, inside the abdomen, as a result of spinning injury. This is the opinion given by the opinion given by expert.
So, if she was not suffering from any disease, then
She may also suffer from disease. It creates a doubt.
no.
It creates a doubt because no external present,
No,
fellowship. And they are residing in the same
Had
house.
there been any medical document or the evidence of the doctor, then it would have created doubt. Otherwise, your submission will not do.
I left before lordship because this was submissions.
Pardon?
Upon the lordship.
That's all right, but
Because of medical report, there is no external submission. And there is a, see, in the same house, all are residing. If something happens, necessarily all are living with the family members. It's not a separate house, the same house, next wall is some person is living.
but
It doesn't-
those persons were not there at the relevant point of time.
The family members are there.
Hmm?
But Bojigan has not taken, the family members are there, the family has no.
How can we, where is the evidence that family members were there? Where is the evidence? That at the time of family members of those households were there?
Because PW1, PW2 has said that when there is there, many people are gathering.
They arrived at the place of occurrence only after the
No.
occurrence.
But the police has not taken any other witnesses of the compound and all, not even Sangita Kakoti, other
No,
witnesses.
police has examined.
Only one, this Anjan Braga, all
No,
others
no,
are
no,
hearsay.
no.
They-
Police has examined the statement of, recorded the statement of Sangita Kakoti also.
But they have not produced.
Prosecution side has not examined her.
This is.
What is it?
This is one of it.
Punorin.